Is there anything that's gonna stab me or poke me or anything like that? On your body? Anything? Yes or no?
I don't think so.
It doesn't inspire a lot of confidence, yes or no?
No.
Alright.
Sometimes they sell it.
Okay. So you're acknowledging me.
On August 13th, 2023, the Palm Beach Gardens Police Department responded to a merchant detention at a local Costco warehouse store in Florida. What followed raises 4 distinct legal questions worth examining: the lawfulness of the detention, Miranda compliance, post-warning admissions, and the scope of the trespass issued. The encounter begins inside Costco's loss prevention office, not in a public space, not on a street. That distinction matters legally. Florida recognizes the shopkeeper's privilege under common law, which permits a merchant or its agents to detain a suspected shoplifter for a reasonable time and in a reasonable manner to investigate the alleged theft. This is a civil law doctrine, not a constitutional one. Fourth Amendment protections apply to government actors. At the moment loss prevention took custody, no officer was present. The constitutional clock had not yet started. The moment the responding officer arrived and assumed control of the subject, that changed. The encounter converted from a private merchant hold into a government-initiated detention fully subject to Fourth Amendment scrutiny.
Yeah, you're around yourself. Just gentlemen would like to see it too. You can take everything out for it.
What do you have in your bag?
Just stupid shit.
You throw all in the box if you like to. Man.
What else in there?
In the pockets. I'll take all this stuff out of your pockets.
Yes.
What else in that bag, sir?
No.
Or something else in there?
It's just a stuff bag.
Okay. Yeah. So, let's go. Let's go. We're gonna go to the office real quick, all right?
To the office and we'll just do this work and get this completed, okay?
All right, about 552. We're gonna be at the LP office. 51 here.
You wouldn't even know. See, you didn't look below. No, he's never going to stop in Costco. Just lost every privilege back on ladies, every time you read it, showing the back track on every camera in this whole warehouse. While you do it. If you did it every time, we're just going to get back call. Mark James! No. They can't do it.
Yeah.
I get there. That's no. If you lose that,
They will not. You can leave the stuff you paid for, and we'll take all this in here. Okay.
I'm searching real quick. Sir, real quick, just so I know you have nothing else on you. Can you still here against the wall? I'm gonna pat you down, make sure you don't have any weapons or anything. Is there anything that's gonna stab me or poke me or anything like that? On your body? Anything? Yes or no?
I don't think so.
It doesn't inspire a lot of confidence, yes or no?
No.
Alright.
Before seating the subject and beginning paperwork, the officer conducted a pat-down. Under Terry v. Ohio, 1968, a limited weapons frisk is permissible when an officer has reasonable articulable suspicion that the subject may be armed and dangerous. The officer asked directly whether anything on the subject's body could cause injury. The subject responded, quote, "I don't think so." That equivocal answer, rather than a clear denial, is legally sufficient to meet the Terry standard for a protective frisk.
Have a seat. I haven't run any 44 or anything. Okay.
Yeah, probably.
I assume you know why we're here. So I'm going to read this to you, okay?
Sure.
I'm required to warn you before you make any statement that you have the following constitutional rights. You have the right to remain silent, not answer any questions, right?
Yeah.
Okay. So what's going on with these items in your card outside the storage?
November 1, signal full.
What?
These items in your cart
That we're not paid
that
for.
were not paid for.
Just
Go for one.
stupid shit.
Is there an Anchorage
We'll
drive?
define stupid shit.
Just,
Imagine there's a 7-year-old driving a golf cart with some 37s on it. driving
I don't
well,
even have an explanation.
last seen
You
heading
can't
west
afford
on
your meds. You resell them. Somebody pays you to do this.
No, sometimes it's Tylenol was for my mom. You know, I
16 cents.
use the allergy medicine, you know, for my kids. Sometimes I sell it.
Okay. So you're acknowledging the.
At approximately 3 minutes into the footage, the officer delivered a Miranda warning before initiating questioning. This is the correct sequence. Miranda v. Arizona, 1966, requires advisement prior to custodial interrogation, not after. The subject acknowledged understanding his rights and then proceeded to answer questions. That acknowledgement, captured on body-worn camera, is the evidentiary foundation for admissibility of everything the subject said afterward. Post-Miranda, the subject admitted to taking merchandise for personal use, for family members, and critically for resale. Under the Fifth Amendment, a voluntary statement made after a valid Miranda warning is fully admissible at trial. No coercion, no suppression argument. The officer later noted on camera that the subject admitted to me after Miranda that framing is legally precise and reflects an understanding of why the warning sequence matters. This was not a procedural accident, it was correct practice.
You guys sit in there, you need a visual.
We're 10-4, thank you. I mean, you're past.
Yeah,
Bring stuff up. I mean, you went to the ring up a bunch of stuff, right?
Yeah,
Driver went up and over the curb.
it's
Okay. Do you have any ID on you? Do you want us to run it? He's in.
Yeah, you see everything right now.
You guys want to trespass?
Yes, yeah, we're gonna post for trespass now, as the officer will explain. The time frame for the city of Palm Beach Gardens is 18 months. However, I'm telling you as a representative of
Alright,
Costco,
they're
you
not
are
able to get
never
the vehicle
allowed
out
on the
of
property or the grounds of any Costco ever again.
out from the curb
Is that
area
clear?
up against the building. Could you just send that to this?
What happened?
Have everything.
Somebody went over a curb.
We will. So, and as my manager had probably explained, what I'm going to do as the loss prevention officer here is I'm going to look in the history of your last shots to see if this has happened in the past. If it has, what I'm going to do is if I can find anything to where my inventory auditor has wiped out any and other products that we think you may have selected, I'm going to go to your first appearance date and I'm going to petition for restitution on anything that I might be able to justifiably say stolen. If we do get awarded restitution, there is a chance that this might be increased to a felony if it is over the amount of $750. We're not there yet. That might be down the road, but I'm just letting you know from Costco's perspective what I'm going to be looking at.
Are you travel 5?
Row 5.
No, sir.
Copy, thank you.
2 separate trespass instruments were issued simultaneously, and the distinction between them is frequently misunderstood. The first is a municipal trespass under Florida Statute Section 8 to 10.0 to 9. Palm Beach Gardens enforces an 18-month prohibition. Return to this location within that window constitutes a criminal trespass offense. The second is a private property ban issued by Costco's loss prevention supervisor, a permanent company-wide exclusion from every Costco location. This is not a city ordinance, it is a private property right, and it has no expiration date. These are 2 legally independent instruments. The municipal trespass expires, the private ban does not. Violating the private ban at any Costco location anywhere can still result in a criminal trespass charge under Section 8 to 10.0 to 9, regardless of when the original incident occurred. The loss prevention supervisor also disclosed the potential for a felony upgrade. Under Florida Statute, Section 812.015, retail theft is a first-degree misdemeanor when the value of stolen merchandise falls below $750. At or above that threshold or with prior retail theft convictions, the charge escalates to a third-degree felony. The LP officer stated that an internal audit of the subject's prior visit history was underway. If that audit identified prior incidents, restitution would be petitioned at the subject's first court appearance. That restitution petition, if granted and combined with the current incident, could push the total value above the $750 line. This is a standard post-arrest enforcement mechanism in organized retail theft investigations and is legally available to the merchant under Florida law.
I guess I'll get some 44 cents. Do you want to... Yeah, just grab it and I'll say it. Yeah. Do you need anything else from that? Like, no, I got his ID real quick. Just hang tight here. I'll get some paperwork.
Who has my license?
We'll give it back to you before.
I'll get it back to you.
Is there something going on, process that I'm not aware of?
You're not aware of? You're under arrest. So you're under arrest right now for shoplifting. We're doing the paperwork. And then from there, they're going to do their little thing and then we'll go from there. Okay, so what this is a paper arrest, okay? So you're technically under arrest right now. We're going to issue this paperwork with a court date, okay? Your court date's right here, September 13th, 2023 at 9 a.m. at the Palm Beach Gardens Courthouse. It's on PGA Boulevard across the street from the mall. It's in the same building where the tax collector is, where you get your driver's license, everything else. Address is right here, 3188 PGA Boulevard. I circled it on the back here. Because this is a lot of carbon copies, I also rewrote it on your copy back here. I rewrote your charge for you as well as the address, okay?
Now, at this point, at September 13th or whatever, is that an arraignment or is that...
That is your first appearance in court.
Okay.
Okay.
Should have an attorney?
That is completely up to you, sir. You know, for as far as I can tell, these guys have video of it. You admitted to me after Miranda that you did this. You know what I mean? If you want to retain an attorney for that, that's fine. It's, like I said, it's completely up to your call, and I can't provide you legal advice. Okay? So I don't intend to do so. I do need you to do two things for me. You print your name right there, and then sign your name right there. And like these guys said, you're being issued a trespass warning as well for 18 months. If you return to this location in the next 18 months, you are subject to arrest, okay? They explain to you the rest of the process, you know, what they're going to do. They're going to go back and review their videos, see if this happened in the past. You know, that might increase it to a felony amount. I don't know what they're going to find. You know better than I do what they're going to find. So if you think there's a possibility that'll happen.
Sorry to call before.
Hey, for gas, I don't know.
All right. Well, good luck to you, sir. We're going to escort you out of the building.
Okay.
The officer issued a notice to appear under Florida Statute Section 901.2-8, which authorizes law enforcement to release a misdemeanor defendant on their own recognizance in lieu of physical custody, provided the defendant signs the notice and commits to appearing in court. The subject's court date was set for September 13th, 2023, at 9 in the morning at the Palm Beach Gardens Courthouse, 3188 PGA Boulevard. The subject was not transported to jail. This was the appropriate resolution for a first-time cooperative misdemeanor defendant. When the subject asked whether retaining an attorney would help, the officer confirmed the right to counsel but declined to provide legal advice. This is textbook Sixth Amendment compliance. Informing a defendant of the right to representation while withholding personal legal opinion is exactly where the line belongs. The responding officer receives a B+. Miranda was delivered in the correct sequence. The Terry frisk was legally justified. The notice to appear was the appropriate charging instrument. Sixth Amendment advisement was precise and professional. The grade does not reach an A because the on-camera Miranda delivery did not include a complete verbatim recitation of all four required components. While the subject's acknowledgement likely renders any post-warning statement admissible, a complete on-camera delivery eliminates all ambiguity at a suppression hearing. The Costco loss prevention officer receives an A-. The merchant detention was conducted within the lawful parameters of shopkeeper's privilege. No excessive force. Communication was clear, legally accurate, and proactively disclosed both the trespass framework and the felony threshold. The fractional deduction reflects the restitution audit language, referencing any and all products we think you may have selected. It edges toward an overly broad claim before adjudication. Documentation of that audit scope will need to withstand a restitution challenge in court. The subject receives a C+. Cooperation and compliance prevented escalation that carries weight. No resistance, no additional charges, signed the notice to appear without incident. However, speaking after Miranda without counsel present was a significant error. Admitting to personal use, family use, and resale of stolen merchandise on camera after waiving the right to silence, eliminated any meaningful suppression argument, and directly corroborated the physical evidence already in LP's possession. 3 lessons apply broadly to encounters of this type. First, Miranda is not a formality. When an officer reads those rights, the correct response is to invoke them. I would like to speak with an attorney before answering any questions is a complete sentence that ends the interrogation. Second, the shopkeeper's privilege creates a legal gray zone. A merchant hold is not a police arrest, but cooperation with loss prevention staff before officers arrive does not protect a subject from self-incrimination. Anything said to LP personnel can and will be documented and handed to responding officers. Third, a dual trespass is not redundant. The municipal ban and the private property ban operate on separate legal tracks. Assuming that expiration of the municipal trespass restores access to the private property is a legal misunderstanding that can result in a new criminal charge years after the original incident. At the time of this analysis, the final case disposition remains unconfirmed. No public court records verified the outcome of the September 13th court date. Based on the evidentiary record LP surveillance, recovered merchandise, and voluntary post-Miranda admissions, any charges filed carried substantial prosecutorial support. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.